Hi, my name is Robert Shelley with Chelle Law, and my law firm assists physician assistants with employment contract issues. Today I'm going to talk about non-competition clauses for PAs. So, if you are signing an employment agreement, and many times in independent contractor agreements as well, the organization that you're working for will require you to sign a non-compete before you start employment. So let's get a couple things out of the way first. Are non-compete agreements enforceable in independent contractor agreements? The answer to that is yes, assuming you're in a state where they are enforceable. There are a handful of states where non-competes are completely unenforceable. So first, you need to check, are you in one of those states? There's only 4 or 5, but that's the kind of the first thing. And then next, you need to think about, all right, well, every state has kind of a different view on non-competition clauses, but they all use kind of the same analysis, and that is, are they reasonable in scope, time, and geography? So those are the 3 components of any non-compete. What are they stopping you from doing? And how long are they stopping you from doing it? And then what is the geographic area that they're stopping you from practicing as a physician assistant in? So when you're signing a non-compete, or at least negotiating one, you need to keep those 3 things in mind. One thing that people miss fairly frequently is the scope of it, meaning if you're a PA working, let's just say you're working for an orthopedic surgeon, you don't want the scope of the non-compete to say you can't practice as a physician assistant, for 1 year within 10 miles of the clinic. You want it to say you can't practice as a physician assistant with an orthopedic practice. That way you have options. If you absolutely cannot move, although you may be a PA that's in orthopedics all the time, at least it gives you the option of doing something else for that year so you don't have to move, and then you can get back into it after the fact. So really make sure that the scope of it is very narrow, specifically to what you're doing. So if you're working for, a dermatology clinic, you can't practice as a physician assistant with an existing dermatology clinic, something like that. 2, time. So most non-competes will be about 1 year in length. Sometimes they'll push it to 2, but no more than that. I don't think any state would enforce a non-compete for a PA over 2 years. So 1 year is kind of the goal. Anything less than that is pretty rare, to be honest. So try to shoot for no more than 1 year. And then last, the geographic scope. Now this can vary based upon where you are geographically. 5 miles in New York City is vastly different than 5 miles in rural Idaho. Think of it this way: if you have a 5-mile non-compete in New York City, it probably knocks out hundreds of opportunities. If you have a 5-mile non-compete in rural Idaho, you may not even have any available opportunities beyond the one that you're working with. So that needs to be taken into account. If you're just in like a normal urban environment, not insanely dense, somewhere between 5 to 15 miles would not be an unreasonable geographic restriction for you not to work within. Anything longer than that, once again, kind of depends upon where you are. I find the Midwest really tries to push it to sometimes 20 or 30 miles, whereas some of the bigger cities, maybe 10. So you need to do an analysis of, all right, well, if this is stopping me from working within this area, how many other opportunities do I actually have in this area? If you don't have any other opportunities, then obviously it's worth focusing on some other issues, when negotiating a contract. If it knocks out dozens of opportunities and there may be not a lot outside of that area, then it could be a huge part of any kind of negotiation for your employment agreement or independent contractor agreement. A few of the kind of myths, I guess, that I'll debunk real quick. One, that they're just absolutely not enforceable. Not true. As I said before, there are a handful of states where they aren't enforceable, but you need to figure out if you're one of those. First, if the employer says, don't worry about it, we won't enforce this, even though we're going to make you sign it, obviously don't do that. You have to be willing to accept anything that you sign. So if you sign a non-compete with a terrible geographic restriction, unfortunately, maybe if you fought it legally, you could get it reduced in some way, but most people absolutely don't want to do that. And then, lastly, as I said before, the scope needs to be tailored narrowly, because they could theoretically stop you from working as a PA in any scenario. So you want it to be the specific thing that you're doing for that practice. So the question always is, well, can they stop me from working at all? Well, yeah, if it says you can't practice as a PA within that area. Obviously, if it's something else outside of the need for your license as a physician assistant, then sure, you can work. They can stop you from working, but they can stop you from working as a PA. So anyway, that's a brief breakdown of non-competes for physician assistants. If you have any questions about your employment agreement or independent contractor agreement, or non-compete clause for that matter, feel free to contact my law firm at the phone number listed below in the description, or you can reach us through our website, chellelaw.com. If you thought this video was helpful, please like, subscribe to the channel. We release videos every single day. All right, appreciate it. Thanks. Bye.